Trump's home in Mar-a-Lago was searched by the FBI. What are the facts without the politics? Don't worry, I got you. My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. So let's start at the beginning. It's the morning of January 20th, 2021. Trump has lost the presidency, and now his team are packing up boxes and other materials and taking them to Air Force One so it can be transported to his home in Mar-a-Lago, Florida. Included in these boxes are Trump's personal items, personal effects, personal papers that he obtained while he was president, and some classified materials. Now, at this time, Trump, who is president, can declassify anything he chooses. As current president, he has that ultimate authority. And he only has that authority to declassify anything until a new president is sworn in. Now, at 12 noon on January 20th, 2021, Joe Biden is sworn in as the 46th president of the United States. And at that time, Trump loses any authority to declassify anything. So this puts former President Trump in an interesting position. Anything that he didn't affirmatively declassify before losing that authority is now still classified. So any classified information, President Trump is going to be treated just like everyone else because he's no longer president. He's just a private citizen. So now all those laws and rules about how to handle classified information now apply to the former president. But when presidents leave office, sometimes they do take classified information. So this is really not a big deal because generally you just ask the person, hey, listen, you made a mistake and took whatever documents and those documents have to be classified. Can you please return them? And it's usually a streamlined process. Now, a couple of days after Trump left office, Trump was contacted by the National Archives. They wanted Trump to return items covered under what's known as the Presidential Records Act of 1978. Now, for those of you who don't know, the Presidential Records Act, which was enacted in 1978 after former President Richard Nixon wanted to destroy documents related to the Watergate scandal. This law mandates that presidential records are property of the U.S. government rather than belonging to the president himself. So violating this law is punishable by up to 3 years in prison and makes it a crime to conceal or intentionally destroy government records, which are now the personal records of the president. So at this time, former President Trump and the National Archives agreed to turn over items covered under the Presidential Records Act. In total, there were about 15 boxes that were sent from Mar-a-Lago to the National Archives to comply with the law. Now, about a month later, after review of the contents of those 15 boxes, the National Archives reported to authorities that classified information was included in the boxes that Trump sent to the National Archives. Federal law bars the removal of classified documents to unauthorized locations by unauthorized personnel. And at this time, Trump is now a private citizen, so he's not authorized to be in possession of these classified materials, but accidents do occur. So let's do a quick recap. At this time, former President Trump may be in violation of the Presidential Records Act, evidenced by the 15 boxes that he took with him to Mar-a-Lago, but they were sent back. And it's possible that President Trump could be in violation of mishandling classified materials. And the evidence of that is obviously the classified materials that were found within the 15 boxes Trump turned over to the National Archives. Now, because it was believed that there were more classified documents that had not been turned over, the Justice Department got a grand jury subpoena for classified documents from Mar-a-Lago. And on June 3rd, the FBI went to Mar-a-Lago to retrieve any classified information left with the Trump team. Now, Trump was present at the beginning of this meeting and greeted investigators, but did not answer any questions. During that meeting, Trump's attorney showed the investigators documents. Some of them had markings that indicated that they were classified. The agents were given custody of those documents that were marked top secret or higher. Now, on June 8th, the Justice Department requested that a stronger lock be put in the storage room where this information was being held because there were concerns that there may be more top secret or classified information at the location. Then investigators got a tip from someone on the inside. This tip from a confidential informant claimed that there were more classified documents, explained what those classified documents were, and where they were being held. On January 22nd, another grand jury subpoena was issued for surveillance cameras in Mar-a-Lago, which the Trump team turned over immediately. Then a search warrant was executed to search President Trump's home for the classified information. Now, Trump's own appointed FBI Director Christopher Wray personally approved this warrant, and so did Attorney General Merrick Garland. Speculation time. It seems like the warrant is based on this tip from this confidential informant that Trump still had classified information. They seemed to use the surveillance footage to verify parts of this informant's story. Now, this is generally how it's done with search warrants, especially involving confidential informants. So when you have a confidential informant, the government needs to satisfy what's known as the totality of the circumstances test. This is from a Supreme Court case called Illinois v. Gates from 1983, where the court said you have to look at the informant's veracity for telling the truth, that informant's reliability, and you have to assess the informant's basis of knowledge. And using all that, you determine the value of that report and whether the information they're providing rises to the level of probable cause, which is required for a search warrant. As an example, if this informant is President Trump's assistant who handled the documents and works there every day, that may be enough to issue a warrant under probable cause. If this informant is some random person like a janitor who just works at the club but doesn't really have any basis of knowledge of what classified documents are there, then that probably would not be enough for probable cause. Now, in a study in development, the New York Post is reporting that the federal government sought documents regarding nuclear weapons during the raid at Trump's Mar-a-Lago ranch. Now, if that's the case, the question is, why would Trump want to just keep documents about nuclear weapons? That doesn't make any sense. But hopefully soon we'll get the warrant application and we'll get the inventory of what was taken. President Trump does have that information. He could release it. The Justice Department is asking for a court to unseal it so they can release it. And then we may get a little bit more information about what were the contents that were taken out of Mar-a-Lago. So those are just the stone cold facts. Now go look for the spin.